Hello, I've just opened our webinar access for attendees, so hopefully you are able to start logging in. I will get started in a few minutes once everyone's had a chance to get in here, but I just wanted to periodically say a few words so you can make sure you can hear me as you're joining. Again, welcome as you are joining. Hopefully you can see the cover slide for today's presentation, Union Organizing Update for Employers. And if you have access to a chat window where you would be able to ask any questions that you may have and you can hear me, then you are in good shape. So we're going to get started in just a couple of minutes, but I want to give everyone a chance to get logged in. As we're waiting to get started, I just want to thank any of you who were logged in or tried to get logged in last week when we were originally scheduled to provide this presentation. Unfortunately, we had some technical issues with our vendor that we could not resolve in time to present that as scheduled, but I'm happy to be able to do so now. So we're gonna give everyone a few more minutes here to try to get logged in. We're just doing all the testing. So we got a little late start to opening the window, but for those of you who are logged in, we'll be aiming for an hour as usual for today's presentation. Okay, thanks for joining us today. I'm Scott Horton. I will be the presenter for today's webinar, Union Organizing Update for Employers. We are just waiting another minute or two to give everyone a chance to get logged in. I just want to make sure you can hear me. You can see the slide presentation, the cover slide for today's webinar. And if you have access to the chat window so you can ask any questions that may come up, then you're all set. Just hang tight and we will get going momentarily. Yeah, as I said once before, if you were logged in or tried to get logged in last week for this webinar, thank you for coming back. I'm sorry we had a technical issue with our vendor, but everything seems to be working now. We have tested and it looks like we should be good to go. So again, I'm Scott Horton with Horton Law in Orchard Park, New York, near Buffalo. I will be presenting this topic, Union Organizing Update for Employers, Mid-Year 2022 Stats and Strategies. This presentation is directly relevant to private sector employers throughout the United States. So whether you are located in New York like we are or not, you will be potentially impacted by most of the legal issues and practical developments and information that we're going to be speaking about today. If you're in the public sector, if you work with a government entity, for example, then the material we're talking about today does not directly apply. States have their various own labor organizing mechanisms. Some states don't have labor organizing mechanisms for the public sector workforce. So this may still be of interest to you, but this will not be as directly applicable as it would be if you are in the private sector. So with that said, I'm going to get moving into the presentation. Just so you know, these slides that I'm going to be using will be available to you at the end of the presentation. And you'll also, if you're registered, get an email tomorrow with a link to the materials. Just a little bit of background on what we're talking about is the legal background arises under the National Labor Relations Act, which is federal legislation in the United States from 1935, which was also known as the Wagner Act. There will not be a test on these dates or names, but for those of you who are interested in a little bit of the historical perspective, this legislation first gave employees what are now known as Section 7 rights and created the National Labor Relations Board, which is a very important agency in Washington with regional offices around the country, not only for union organizing issues and elections, but also for various alleged violations of the National Labor Relations Act, which they administer. In 1947, the Wagner Act was amended by the Labor Management Relations Act, also known as the Taft-Hartley Act. Again, this is more historical trivia, but about to show what changed in 1947, and that is a little bit relevant to some of what we're going to be discussing today. So the Section 7 rights that were brought in originally in the National Labor Relations Act are the right to self-organization, the right to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Collectively, these give employees in the private sector throughout the United States rights to work together to try to negotiate better terms and conditions of employment, including the right to hire a third party to come in and negotiate with their employer, and that is a union in common parlance. The 1947 amendments added this last bullet point to Section 7 of the National Labor Relations Act, which can be very important, and that is the right to refrain from any and all such activities. So employees are not obligated, obviously, to unionize in the first place, and they're not obligated generally to work with each other if they don't want to. So what are the ramifications of that in the union election organizing context? We will address that in a little bit more detail as we move forward. Again, if you have any questions, feel free to type them in as they come to your mind in chat, and I will maybe answer them immediately if I happen to see it at a convenient time. Otherwise, we'll have question and answer at the end. Again, aiming for about an hour total for the presentation, but I always stay on as long as possible to answer any questions that come in. So I mentioned the National Labor Relations Board. This is the federal agency that enforces the National Labor Relations Act. There's a 5-member board in Washington, D.C., and 26 regional offices scattered throughout the United States. Obviously, there's 50 states and 26 regional offices, so not every state has a physically present location of the National Labor Relations Board, but they are spaced out such that the more heavily unionized workforces have an office closer on average than less unionized parts of the country. For example, New York City essentially has 2 regional offices, where the remainder of New York State has 1 regional office that is based in Buffalo, very close to where I am located. And obviously, you can find out which regional office is closest to you wherever you are, and which one then would adjudicate any issues that arise in your workplace. The National Labor Relations Board, through these offices and all the way up to appeals to the National Labor Relations Board, process unfair labor practice charges. That would be complaints that either the union or the employer have violated the National Labor Relations Act in some way, and representation petitions. And representation petitions are primarily the topic of our discussion today. Representation petitions are ways that employees, unions, and even employers can file with the National Labor Relations Board to seek to have some change in the representation status of employees. In case you're wondering whether this might affect you. The National Labor Relations Board has generally broad jurisdiction within the private sector, again, meaning non-government. If you're a publicly traded company, you could still easily be subject to the National Labor Relations Act. So private here just means that you're not government, really. It also applies to labor organizations and to employees, of course, who work within otherwise covered businesses. There are some general industry exceptions for agricultural workers, interstate railroad, and airline employees, but in other forms of industry, if you're not the government, you may be subject to the National Labor Relations Act. But the National Labor Relations Board does have discretion not to assert its jurisdiction over some businesses, even though they otherwise affect commerce, and therefore Congress had the authority to legislate unionization in those workplaces. The National Labor Relations Board, therefore, has established a set of coverage standards which vary by industry. Generally speaking, though, these are relatively small thresholds. So the annual revenue thresholds range from $50,000 to $1 million, depending on industry. If you're a very small business and there are a few other carve outs, then you might not get the interest of the National Labor Relations Board, even if theoretically you are literally subject to the act. That means if employees at a very small company wanted to unionize, it is possible the National Labor Relations Board would say, no, I'm sorry. Some states, but not all, have their own state agencies that could then fill the gap. New York, for example, does have a state law that would allow small employers who are in the private sector and not subject to National Labor Relations Board jurisdiction to still seek similar rights, including organization under state law. So if you're in a different state and you're really small, the NLRB isn't dealing with you, you should check and see whether there is a state law that might still allow your employees to unionize. We're going to really be getting into some numbers here in a moment, but one more piece of timely information, I think, on this subject that I wanted to share is there has been over the last year or so more talk of something called the PRO Act. I think it stands for Protecting Right to Organize Act or something very close to that. This is a very wide net piece of legislation aimed to protect workers and maybe even more than workers, unions. It gives more workers the right to unionize in various respects. It restricts employers' ability to resist unionization in several ways, including imposing new penalties on employers if they are found to have violated the National Labor Relations Act. At one point, we were increasingly concerned that this legislation would pass, and I say that speaking from an attorney who represents employers. Obviously, there are many people that are employees or unions and their supporters that would be very happy to have this act passed. But again, most employers would not welcome increased penalties and restrictions that this act would impose. But as of now, it is highly unlikely that this legislation could pass the US Senate. Therefore, we don't anticipate it becoming law anytime particularly soon. But if it did, it would be a dramatic sea change in the way employees can become represented, as well as many other protections that they would gain under the National Labor Relations Act. All right. So the last background piece of information I want to give before we really start diving into the numbers, what they mean, and whether you should be increasingly concerned that your workplace may be about to organize, if that is a concern, as well as we're going to discuss some of the path to workplaces that are already unionized, removing that union from representing them. But I want to go through the basic organizing process and what we are talking about when we are thinking about union organizing in the most common situations. So the typical scenario is, for whatever reason, the union and some interested employees at a company start talking. It may be that these employees worked in a unionized workforce at another employer, and liked having their union representatives, or it could just be that the employees, for whatever other reasons, have become somewhat disillusioned with something that is going on at work and reach out to the union, hoping for some assistance. It is also possible that, for whatever reasons, the union has prioritized a particular company, and hoping to gain the representation rights regarding those employees. So, if there is enough interest or enough motivation among some interested employees, then the employees at that workplace may start to be asked to sign union authorization cards. These are basically simple enough documents that say, I want to be represented by a particular union. The union may then go to the employer and voluntarily seek that the employer agree to negotiate with the union and to recognize them as the exclusive bargaining representative of certain employees. To do that, the union needs to be able to show at least a majority support among employees. So, more than half of the employees have signed authorization cards, for example. That being said, at this point, there historically, and as far as we know, still is not an obligation for employers to then voluntarily recognize the union. The PRO Act may have attempted to change that, and it is possible that the current National Labor Relations Board might be looking for circumstances where they can argue that, under compelling enough facts, an employer has to voluntarily recognize the union. But again, historically, as far as we know now, that's not an obligation that employers have. The employer can say, no, thank you, in which case, and often directly, the union can go to the National Labor Relations Board, file an election petition saying, we would like to have an election to let the employees at this workplace vote to determine whether they want us to represent them in negotiating with their employer over the terms and conditions of employment. If the union chooses to do this, either after the employer has turned down voluntary recognition or as an alternative to even asking in the first place, they actually only need to show 30% of employees support being represented by the union at the time of filing the petition. As a practical matter, the unions usually go for much more support before they would even file the petition, because once they file the petition, there's not a whole lot of time before the election would take place in most cases, matter of, 3 or 4 weeks. So they would want to make sure that they feel comfortable they have sufficient support before they start the election process. But if for some reason the union wanted to, they could do it with as little as 30% of the employees having signed cards or a petition showing that they want to be represented. There are a few issues that can arise when those petitions are filed, and those are generally listed here. My main point in throwing these out at this point is just to let anyone that works for a company that does receive an election petition know that, even supposing you are pretty confident how the election is going to go one way or the other, there are some issues that you want to be very attentive to before you just let the election take place. First of all, there are various election bars. For example, if there is a current contract that has just been negotiated with a different union, then that is likely going to bar anyone from coming in and saying they want to be represented by a new union. There are ways to do that again, but there are certain time periods that would have to be done. There is the question of who is in the bargaining unit. So the bargaining unit is the group of employees within the company that would be represented by the union. In almost all cases, the bargaining unit is not all employees in the workplace, because if nothing else, we have this next point that there's a distinction between employees and supervisors. Obviously, within every company, there has to be someone who the employees represented by the union would actually negotiate with. So, at the very least, whether that's ownership or the highest level executives, and where you draw the line down to lower level management can become a controversial and contested topic. The election details sometimes are important. What time and day and location will we have for the election itself? Usually, these elections take place in person somewhere on the employer's premises, and there are details that need to be worked out on that. And sometimes it's important to figure out what the right day and time is for the election to ensure that the most employees as possible will actually be available and have access to come and vote in the election. Um, so when they file the petition, the union will propose a location and a date and time, but it's very common that that gets negotiated and worked out to be something different than what the union originally proposes. Finally, there could be unfair labor practice charges filed. This could happen either totally independent of the union organizing activity or related to it. For example, the union may claim at some point in the process that the company did something inappropriate to try to sway the outcome of the election, or conversely, the company could file something saying that the union did that. So those types of charges may have been pre-existing before an election petition was filed, or they could come up right after the election petition was filed. In either case, they may have to be resolved before the election could take place. All right, so now's where we get into the numbers and the real update portion of this presentation, which I'm very interested to share with you, and what has kind of inspired this presentation and some articles I've written earlier this year are some announcements by the National Labor Relations Board that are geared at demonstrating that the National Labor Relations Board, in particular its regional offices, are busier than ever. Honestly, the NLRB is looking for additional congressional funding because they're so busy. And in making these press releases, the basic point has been that more election petitions are being filed than in the past. So I have downloaded the data from the National Labor Relations Board website and digested it in various ways and offer some maybe deeper insights than what the NLRB press release has addressed. So their headline in their latest filing in July was that the first 3 quarters union election petitions were up 58%, exceeding all fiscal year 21 petitions filed. There's actually a lot to that seemingly simple headline. I'm going to try to break it down. First of all, the NLRB, like the federal government's fiscal year, begins October 1st. So the current 22 fiscal year ran beginning October 1st until September 30th of 2022. So that's what they're talking about for the fiscal year. The first 3 quarters basically meant through June 30th of 2022, dating back to October 1st. The exceeding all fiscal year 21 petitions, again, that would mean the fiscal year that ended September 30th, 2021. And these numbers are correct. They are up 58% over the first 3 quarters of fiscal year 21, and they do exceed all of the petitions filed in fiscal year 21. But the next step to really understanding this is to break down what the NLRB is referring to here when it says union election petitions. So there are actually a number of different procedural filings that are being lumped together as union election petitions. A small number of them fall into these categories on the screen. These categories are probably not of too much concern to most of you, but I just put it in there for completeness. There are various procedural methods where some party or another can file with the board seeking an election that may or may not result in an election, but to some way clarify who is the union and who's included in the union. Often these involve a situation where there's already a union in place. So there's a relatively small number of these assorted filings, 84 through the first 3 quarters of fiscal year 22, but these are included in the total numbers that the NLRB is referring to. The more substantial number of petitions are in 2 categories that are of more interest generally, I think. These are representation elections and decertification petitions. So the majority of the cases overall are representation election petitions. These are cases where the union files the petition saying we want to represent some previously unrepresented employees in your workforce. This might mean the company's never been unionized, or it might mean the company has unions, 1 or more unions in place, but some employees have not been previously included in a bargaining unit, and now, whether it be an existing union or another union, wants to represent those employees in a new bargaining unit. So there's over 1,500 of those cases so far this fiscal year, and then the decertification petition is essentially the opposite, where an employee goes and files with the National Labor Relations Board saying, yes, I'm currently in a bargaining unit, I'm represented by a union, but I no longer want to be represented by a union. There are 236 of those filings in the first 3 quarters of fiscal year 22. So as you can see, there's, about 6 times as many representation petitions filed as there are decertification petitions. But in both cases, I think that these are more the type of filings that people are thinking about. If they aren't just thinking about the representation election petitions, they might also be thinking about the flip side of that is how do we end recognition. So these are the lion's share of what the NLRB report is alluding to. But again, there are those 84 other cases that also fit into the mix. So let's look at just the representation election cases. These are probably what most readers are thinking of when they read the headline or the press release or the articles that are coming out based on the NLRB release that generally suggest that unions are increasingly seeking to represent employees in the private sector throughout the United States. On the raw numbers, this number is actually higher than the 58% of the total cases. There's a 70% increase year over year for the first 3 quarters in representation election proceedings. However, 313 of those petitions, which is a full 20%, involve Starbucks stores. So if you took out the dramatic number of Starbucks petitions, the year over year increase would only be 36%. Then we say, okay, well, it's still up 36%. Yes, that's true, 36% increase from fiscal year 21. But if we go back to pre-fiscal year 2020 levels, the non-Starbucks cases are basically at the same level as they were pre-fiscal year 2020. What's interesting about fiscal year 2020 and fiscal year 2021? Well, of course, we were under the impact of the coronavirus, COVID-19, isolations and quarantines and lockdowns. And there are various ways to look at these numbers and other federal employment case filing numbers, all of which suggest that there was a dramatic decrease in filings as a result of the pandemic. For various reasons, people weren't actually working. It wasn't as easy to get anything done. It might not have been as easy for unions to try to meet with employees. Employees may not have been as focused on whether they were represented by a union or not. I'm sure there were cases that the pandemic prompted unionization efforts because of the way employees felt they were being treated during the pandemic. But on the whole, it's almost certain that that had a big slowdown impact on union organizing for 2 years. So here is some statistical showing of what I just said. These are the total cases involving unions filing to represent employees. And you see the big uptick in the most recent fiscal year. These are all the first 3 quarters of the year statistics for each of these past 6 years. So yes, 1573 is higher than any of these years, but these include the Starbucks cases. When you take Starbucks out, you can see there's 1,260 cases this year, still more than the 2 previous COVID impacted years, but in fact, 1,260 is almost exactly the average number of cases that were filed in the 3 years preceding COVID, which was 1,255. So my interpretation of this data is, yes, there are more cases than there were last year by far. Yes, there are more cases there were in the last couple of years. Yes, Starbucks is a very unique situation that is no doubt putting additional strain on the National Labor Relations Board staff and their regional offices, but you can certainly evaluate for yourself whether what's going on at Starbucks is as likely to impact your workplace and your employees' interest in unionizing. Certainly, I think there's reasons that, especially if you're not a corporate-owned chain fast casual restaurant, you might say that I'm more like these 1,260 cases than I would be like the 1,500 or so, including the Starbucks cases. Now let's look at the flip side, because another part of the analysis is to the impact of COVID over the last 2 years is, well, let's see what's happening with decertification elections. If there's just an increased sentiment toward greater unionization throughout the country, then that might explain why representation election petitions are up. But as it turns out, we also have a 42% increase year over year in the first 3 quarter filings of decertification elections. Notably here, there is no Starbucks impact because there have been no decertification elections involving Starbucks. In fact, there probably couldn't yet be any because all of the Starbucks that are unionized have unionized in the last year, and you have to be around for more than a year before employees can try to decertify. So what does that altogether say? That we have a 42% increase in decertification elections year over year, and only a 36% increase in representation elections if you take out the Starbucks cases entirely. I think that's pretty good evidence that the numbers are not just showing some dramatic increase in employee sentiment of now wanting to become unionized. I'm sure in some workplaces that is the case, and maybe there's a Starbucks impact on some other similar restaurant operations, but on the scope of private sector industry at large, I think it's hard to look at these data and make any generalization that there's an enhanced interest in unionizing. Certainly the numbers are up, and there's probably the combination of there were petitions that might have been filed earlier, but for the logistical issues created by COVID, um, and maybe some of those cases are now being filed. So that both is one less case that would have been filed the last 2 years and one more case that is being filed this year. But again, however you want to slice it, it's hard to jump to too many drastic conclusions about what's going on right now, at least if you're not Starbucks. Again, as it happens, the decertification election statistics show that we're right back to pre COVID levels. Here are the numbers. Again, there's no Starbucks impact. If we then go do the same thing, the 3-year average for the first 3 quarters of the 3 years immediately preceding COVID, then we find the number to be almost exactly what it was for the first 3 quarters of fiscal year 2022, 236 this year versus an average of 242 in the pre-COVID years. Just to give some more details on what's going on with the elections that are taking place. Here's some information on the outcome of elections. One thing I want to point out before I dig into these statistics is that all of those numbers are based on just raw filings. So theoretically, any union could go and file a representation petition. If, for example, they don't have at least 30% support, then that would likely get dismissed very quickly. Usually that doesn't happen. Unions know they need to have that support, but there are many other reasons why petitions end up getting dismissed or withdrawn for some reason and never resulting in an election. Likewise, on the decertification side, there are many reasons why an employee goes and says, I don't want a union, but for some reason, the NLRB cannot at that point in time process an election. So what does that mean? That we look a little further for representation elections, about 75% of the time that a representation election petition is filed, will there actually be an election? So about 3/4 of the time there's an election, a quarter of the time, for whatever reason, there's not an election. Once there is an election, the unions win a majority of the elections, but when you factor out the number of cases that get dismissed or withdrawn without an election for some reason, it's about half of the total filings result in a union being recognized. On the decertification side, they're more likely to get dismissed. I think you could probably fairly assume that a large part of that is because you have usually individual employees filing rather than unions. They're less likely to know all the parameters of when to file and how to file. So only about 60% of decertification petitions end up in an actual election being held. Again, unions lose a majority of decertification elections. Kind of makes sense that if you're the one filing, you're more likely to win. So if the employees are filing to get rid of the union and there is an election, the union's going to lose a majority of the time, but overall, only about 35%, about a third of decertification election petitions result in unions being voted out. To just give some more data on that, for those who are a little more curious how this breaks down, again, there's a sort of statistical anomaly in fiscal year 20. The elections that were held were only won by the union 62% of the time, but other than that, they're usually somewhere in the range of 72 to 73% of elections actually held going in favor of the union. This is without Starbucks. I note now on the slide that the union has won 86% of the Starbucks elections. So all of those elections have taken place in the current fiscal year. So if you added those cases in, the current fiscal year statistics would be 76%. Still not dramatically different than the overtime average, but it is up, but it's primarily up again because of the disproportionate success that the union is having in organizing Starbucks stores. By comparison, the percentage of decertification elections lost by the union. So again, once the election actually occurs, over time averages somewhere in the 60, maybe 5%, 66% range. This year it's at 72%. It's hard to make too many conclusions about what that indicates, but again, it certainly doesn't suggest a dramatic shift in employees' interest in being represented by a union overall. There's still people who don't want to be represented by a union. And I note that these fiscal year 2022 numbers have some impact in the fact that many of the cases that have been filed this year wouldn't have yet reached an election. These are results through some date in late July when we calculated this data. Some cases will continue to process to elections, and it is possible for whatever reason that some of the cases that have already reached election would have a greater or lesser likelihood of one side or the other winning. But still, I think it's fair to say that all these numbers are pretty much where we generally expect them to be. A little bit deeper dive into the data, looking at a state by state breakdown. Some of this won't be too surprising. If anyone has a question about a specific state, I have that data and could answer it. But overall, the largest percentage of union representation petitions, these are the petitions where people are seeking to be represented by the union, come in states that have sort of a history of being considered union friendly or more pro labor. California, New York, Illinois, Pennsylvania are the top states by percentage. And pretty much all of the top states would be those that would typically be seen as more employee and union friendly. If we break it down compared to population, California is not as much of an outlier anymore because obviously California has a larger number of citizens than most states, all states, but dramatically more than most states. There, however, New York, despite being relatively well populated, is still disproportionately most likely to face representation petitions. Oregon, Washington are up there as well. The one arguable outlier here is Missouri. Missouri is the one right to work state on this list here. And, you know, there might be different reasons for that. It could be that the Starbucks data is skewing that a little bit, but there are also two large cities in Missouri and Kansas City and St. Louis. We didn't break it down to the city level, but it could be that in those particular metropolitan areas, the numbers are more disproportionate. And then at the bottom of that side of this chart, we're showing the lowest state or the lowest number of union representation petitions as a percentage of population. And probably not too surprising that Texas and Florida are at the top or bottom of that list, however you want to put it. In other words, compared to the number of people in Texas, they're disproportionately less likely than any other state to seek to be represented by a union. North Carolina still makes that list, and Georgia. So again, you would expect many of the southern states to be in that category, and in fact, they are. A little bit more detail for you If you're interested in what it looks like size-wise for unions trying to organize workplaces, the mean or average unit size sought overall this year is about 56 employees. This is not perfectly accurate data because this is based on how many employees the union says it's trying to organize. In almost every case where there's any number of employees involved, the union doesn't get it exactly right. I mean, not that they necessarily got it wrong, but by the time the cases actually got processed, somebody has left employment or been hired or something like that. So, but it's pretty close on average. The mean unit size, if you want to look at that, the mean would sort of take out some of the outliers, really high numbers and really low numbers. The mean unit size gets it down to 50 employees. That's primarily because there's some super huge units that are sought, including like some of the Amazon facilities. The mode size, kind of interestingly, in other words, what is the most common unit size sought in a representation petition, is actually only 5 employees. So certainly there are many cases where unions are trying to represent a relatively small bargaining unit. And then I'm sorry, I I missed part of my point on those last two. That was where the union wins. That wasn't all together. So the average number, that's not excluding the statistical outliers. That's the average number where the union wins was 50, and then the average or the most common number where the union wins was 5. What I got ahead of myself on, the median unit size, this takes out the outliers, is only 20 employees. So depending on what you want to call average, it could be 56 or 20. The average Starbucks size, just in case you're wondering how they fit in, since they have so many cases, is 25 employees. So not super large, but not super small either. They pretty much are probably affecting this median unit size where unions win. It is probably likely then that if you took out the Starbucks cases, that number would be different by a relatively small margin. Okay, now that was the statistics, and here is sort of some of the strategy or best practice or analysis side of this presentation to wrap us up before we answer questions. So again, I represent employers. I'm assuming that most of you attending this webinar are human resources, labor relations, in-house counsel for employers. It's not surprising. I think everybody understands for many reasons. Employers generally prefer not to have their employees be represented. That there are exceptions to that, but assuming you're an employer who wants to remain union free, what do these numbers mean? Well, generally the numbers mean that I don't think there's a dramatic shift right now, but we are at least recovering from a decline that COVID had introduced the last couple of years. And of course, the only number that really matters to you is the petition that may or may not be filed at your workplace. And certainly, just as always been the case, it is possible that a union representation petition could be filed at your workplace if your employees become so inclined. What likely prevents employees from being so inclined more often than not includes treating employees with respect, which certainly sounds like a good idea, but isn't always so obvious or practiced in every workplace. Listening to employee concerns. A lot of talk about open door policies, for example. If employees don't feel that their concerns are being heard, then they are more likely to look for an outside party, i.e., a union, to help them get those concerns addressed. Um, Certainly a good idea to have well-trained managers. And here I just mean, frankly, good managers. And I mean good managers who actually know how to interact positively and respectfully with the people that they manage. A lot of managers have certain really valuable skills to an organization, but that might not have much positive impact on staying union free if their skills don't include positive ways of dealing with their employees. And generally, putting a lot together in my last bullet point on this slide is, if there is any sort of union organizing effort, or even before there would be, you need to understand that employers, through their managers, are able to present facts, opinions, and examples about unions, but they cannot threaten, interrogate, make promises, or engage in surveillance of union organizing efforts. So, this means ideally you're aware of the do's and don'ts before the first union organizing activity takes place, because the first time an employee comes up and says, I'm trying to get us represented by a union, if a manager were to say, well, who else is interested in that, that's a risk of unfair labor practice for interrogating the employees about the union. If, on the other hand, the manager says, I used to work at a unionized facility and I ended up spending more in my union dues than I got in increased wages, and assuming that's factual, then that statement, historically at least, should be okay. So there way more details that go into that than I can address here generally. But again, I just want to make sure, if you're not already aware and you're in a position where this might come up in your workplace, that there are some do's and don'ts and lines that need to be walked. And frankly, the lines do shift from time to time and may be shifting now, as we currently have a relatively pro-labor National Labor Relations Board, and the General Counsel of the National Labor Relations Board has made it clear that she has some views that are more aggressively restrictive on employers than some of her predecessors. So, what is the primary thing to do if you have, in fact, received an election petition? So, again, it is possible the union will come to you and ask to recognize them as the employee's representative. Assuming you've said no, and then they file with the NLRB, then you will get a copy of that petition, at which point the most important thing to do is to maintain the status quo. You can't rush to give the employees a pay raise, because that would be interpreted as trying to persuade them not to vote in the union. So whatever the current terms and conditions should generally remain the current terms and conditions until you at least resolve the election petition one way or the other. At that point, it's increasingly important to educate supervisors on the do's and don'ts. It's also important to recognize who the supervisors are, because again, that's a legal issue, and it's not always clear cut. Also encourage employers to evaluate their bargaining unit composition carefully. The union can basically ask for whatever they want in the first instance. They could say, we want to represent all the non-supervisors in the company, or they can say, we want to represent these 3 employees who are janitors on the night shift. And depending on the circumstances, there may be reasons to expand or contract a bargaining unit. Both the union and the employer might have different interests in how the unit is composed. So you want to think through those issues and not just rush to the election in most cases without making sure the right people are going to be voting, because whoever does vote, whoever is in that bargaining unit, the union wins, those people will now be in that bargaining unit, and the company will have to negotiate with the union on their behalf. The final key point is to make sure to comply with all deadlines and provide required information. The National Labor Relations Board will tell you what those deadlines are and tell you what you have to do and what you have to provide and when you have to provide it. But if you don't do it as the company, then it is possible that that will prejudice you in some way in the election. You will lose the right to make an argument about what the bargaining unit should include, or other possible negative consequences. The flip side points for employers: if employees are trying to decertify the union that represents them in your workplace, here are some important take homes. It has to be initiated by non-supervisory employees, so people that are in the bargaining unit. Essentially, they can't be assisted by management or by supervisors. There's, a little bit of gray area in what that means. I mean, it historically has been okay if an employee says we want to get rid of our union, for a supervisor to say something like, well, I can't, help you with that, but you can go on the internet and make sure you look up whatever the relevant timelines and procedures are. That's probably not so much assistance that it's problematic, but if you certainly let them use work time and work equipment to generate petitions and get them signed and stuff like that, then there's certainly more likely to be a problem. Again, you need to maintain status quo, which may mean holding off ongoing bargaining with the union, might mean continuing ongoing bargaining with the union. It's a little bit more complicated in this situation, and it's very important in just about any case to work with experienced labor counsel regarding issues that might arise, including upon presentation of a decertification petition, whether the employer should withdraw recognition of the union, again, whether they should continue to bargain or they should put everything on hold until the election takes place. These get to be pretty complicated issues for employers. The employer itself, in some cases, might be able to file a petition if they get an unsolicited showing of loss of employee support. So if the employees come to the company and say, hey, we've all signed this saying we don't want to be represented by the union anymore, there may be situations where even if the employees haven't filed with the National Labor Relations Board, the employer could do so. There may even be cases where the employer could just stop recognizing the union based on that showing without filing anything, which may or may not put the burden on the union to then file a petition. So again, these are potentially complicated scenarios, but they do happen, as I showed earlier, at least, a couple few hundred times a year across the United States. So if it happens in your workplace, you should be sure to know that there are issues to look out for. Just add this in. These are the time periods for the decertification. The contract has to be in place for at least 3 years or have expired. If there is a contract that's been in place for less than 3 years that is not yet expired, there is a certain limited period of time between 90 days and 60 days before expiration that decertification could be filed. There's a little bit different time period if you're a healthcare provider. Again, you can figure these out easily enough, but I just wanted to include it in the materials in case it becomes relevant. And, we'll continue to try to monitor this data. If suddenly we do see a huge unexplained or otherwise unexplained uptick in union organizing or changes in a particular geographic area or something like that, we'd be happy to try to get information out about it. The fastest way we get our information out is through the company's LinkedIn page, which you can find here. Just look for Horton Law on LinkedIn. I'm about to now give you the link to the slides, but I will be happy to answer any questions that there may be. I don't think we have any in queue as of yet. So thanks for everybody listening attentively. Hopefully it's been very informative. I will certainly wait to see if there are any questions and then answer them. But I'm going to go ahead and make the slide link available. Again, assuming you're watching this because you've registered for the webinar, then you will get an email with a link to the materials after the presentation. But if you want it right away, here it is. You could click for it. And again, I'm just going to hang on. We're right about at our hour, so I think this timed out well, but I will certainly hold on to see if there are any questions. If you have a question and don't have a chance to type the whole thing out, go ahead and push enter and type something in so I know that you have a question, and then I'll know to wait. So at this point, I still don't see any questions coming in. Hopefully you found the information very informative as presented. There, are the statistics and the procedures and um, some of the concerns and best approaches covered in this material. So hopefully you will find that helpful, if not immediately, but if you ever get in the situation where these concerns are relevant in your workplace. But not seeing any additional questions coming through, I'm going to go ahead and wrap up the presentation and look forward to seeing you at our future webinars. Thanks so much.